An extraordinary day of judgments and commentary as Joey Barton has been sentenced for grossly offensive communications offences. Zarah Sultana doesn't seem to know what a British citizen is, and probably one of the strangest and patently absurd lines I've ever seen in a judgment in the nurse Sandy Peggy case with the trans issues. I haven't read the full thing just yet. It's a very long judgment, but I've skimmed it. I found one or two very strange things. I'll come back to that a little bit later. But first of all, a teeny tiny favour. You know what I'm going to ask. Please do subscribe to the channel. We are near 900,000 subscribers, which means I'm on the final countdown to 1 million subscribers. I'll be very grateful. Thank you very much for doing that. Let's get straight to it, shall we? So let's look first of all at, let's start with Zarah Sultana's message here on X. Now, some people, I will caveat, some people will say she doesn't really mean it. That's not precisely what she meant. Well, it's sort of what she said, so I'm going to call out what she said. Let's take a look. So she says here, it's 2025 and we're still living as subjects, not citizens. It's time for a referendum on the monarchy, she said. Now, this is actually, it was subject to a community note. It had been approved and then it seems to be open for rating. The reason for that is, of course, that she's wrong in that we are living as, well, some of us at least, living as British citizens and have been for a very long time. And also there are quite a lot of different ways you might take a look into it. Maybe it'll be subject for a separate video on how many different ways you can become a British citizen. And not only that, it is still, at least technically, a criminal offence to call for the abolition of the monarchy, punishable by way of life imprisonment under the Treason Felony Act of 1848. And although many people claim that it is just a technicality, would never be used, The Guardian challenged it unsuccessfully in the High Court in 2003, and in 2013 the Ministry of Justice had to admit that it had wrongly announced that this had been repealed and that it remained an offence. So technically speaking, Zarah Sultana's post here calling for a referendum on the monarchy could be seen as calling for the abolition of the monarchy, reading specifically with the wording here, if any person whatsoever shall, within the United Kingdom or without, compass, imagine, invent, devise, or intend to deprive or depose our most gracious Lady the Queen, obviously that would apply to the King, from the style, honour, or royal name of the Imperial Crown of the United Kingdom, and lots of other things, and it includes by publishing any writing or by any overt act or deed, every person so offending shall be guilty of felony, and being convicted thereof shall be liable to be transported beyond the seas for the term or his or her natural life. Obviously very old criminal language, which originally meant to be deported to a penal colony, most commonly Australia, and then to be construed as reference to imprisonment, either for life or any shorter term. So her comment, as simple and silly as it is, does raise a question mark, even if it is a technical one and even if it would never actually be prosecuted. But speaking of prosecutions, many of you will have heard that Joey Barton has been sentenced for grossly offensive comments, and some people might be complaining that this is against free speech, but this was decided by a jury, not by a judge. So a little bit on that judgment here, because I've got the sentencing remarks here. Now, many of you will recall that in previous videos I've said that these comments must be grossly offensive to cross the threshold of criminality. And that is precisely what we have here, because many of them were race-related and so on, and they did cross the threshold. The jury found that they did cross this threshold. So let's take a look at this. So the judge says here, you are to be sentenced by me today for a total of 6 offences of sending electronic communications that were grossly offensive. Your purpose, or one of the purposes, to be causing distress or anxiety, contrary to Section 11B of the Malicious Communications Act 1988. You were unanimously convicted, everyone in the jury agreed, of these offences, counts 2, 4, 6, 8, 9 and 10, on the 7th of November. Following a trial. You're acquitted of 6 other related counts. Now, part of what made this worse, if you like, was the size of the following, which was referenced here. On X, formerly Twitter, he had 2.8 million followers at the time. The comments were made against professional footballers and broadcasters Eniona Aluko and Lucy Ward. Now, the judge did make a preface here to the rest of the judgment so that people can understand it, and hopefully you will by reading it or by listening to it, part of it from me. The judge said that it's right that I say something about the nature of these offences in the context of a modern, liberal democracy that rightly places a high value on the principle of freedom of expression, including freedom of speech. Now, obviously, those two are subtly different. Expression is one thing and speech is encompassed within your expression. The judge said, as the jury was directed, such a freedom is a cornerstone of our society. It guarantees the right of every person to exchange information, debate ideas, express opinions, even those that are controversial, unpopular, or offensive. In a mature society, we must recognise that allowing people to express ideas that others find offensive is one of the costs of this precious freedom. The mere plea of feeling offended by comments about one's choices or competence can never justify limiting free speech. To do so would undermine the liberal and democratic foundations of our country. However, that freedom is not unlimited. It does not extend to communications which judge objectively what would an ordinary reasonable person think by the standards of reasonable, fair-minded and informed person in our contemporary, open, just, multiracial, equal and diverse society go so far beyond what is tolerable that they are properly described as being grossly offensive. The criminal law intervenes only where that high threshold is crossed, where the message is so extreme, degrading, or dehumanizing that it exceeds what a free and democratic society can reasonably be expected to tolerate, and where the sender's purpose, or one of the purposes, to cause distress and anxiety to the recipient or others to whom they intend the content to be communicated. So that, I felt, is important for anyone that has a sort of cursory glance at this case and feels that it somehow infringes free speech. It at least gives you the judge's balance on this thing, bearing in mind it was a jury that convicted him and not the judge. The judge then went through the comments complained of in counts 2 and 4 and then 6, 8, 9 and 10. I won't read them out, that's not necessary. You can go and read them if you are so interested. But then the judge came down to the sentencing. So if you read those, you'll get an idea of what it is that the jury found crossed that line, and then the judge came to sentencing. For each of these offences, I impose a suspended sentence order of 18 months duration. In other words, whatever custodial sentence is passed, it is suspended for 18 months, so it is not activated. So he does not go to prison for 18 months unless he breaks any of the requirements or commits further offences, etc. On counts 2 and 4, those were racially aggravated offences. The judge said there'll be a custodial term of 6 months. And on count 6, 8, 9 and 10, custodial term of 4 months. All terms to run concurrently and all suspended for 18 months. If during that 18-month period you commit any further offence, whether or not the same type, you'll be brought back to court and it is likely that you'll be required to serve some or all of the 6-month period. That's the longer of the two. They're all concurrent, all running together. It's a total of 6 months. That is not the end of the matter, the judge said. For the next 12 months, you'll be subject to a rehabilitation activity requirement for up to 20 days, and you're required to complete 200 hours of unpaid work in the community. And finally, there is a monetary aspect, although this is not a fine as such, but he does have to pay the prosecution costs in the sum of £23,419.80. So this is an example where speech can become grossly offensive. So it is a bit of a warning to you that a jury found this to be grossly offensive. A jury found that these comments and these remarks in a series of posts crossed the criminal threshold and was such that he ought to be convicted. So next time you are posting something, do have a read of this judgment. Have a look at what kind of comments were posted. I'm not going to read them out, but they were on screen if you want to go back and pause it and you can read them, get an idea of them. But those are the kind of things that do cross the criminal threshold. But now on to Sandy Peggy, the Fife Health Board and Dr. Beth Upton. Spoiler, I think this will be appealed and I think the appeal will be successful. Sandy Peggy was successful in part and unsuccessful in part. This is the summary. I've also got the judgment. I'll read bits of this to you first, then one paragraph of the judgment, and then I'll probably come back and do a more in-depth video on it later. But I'm not sure I like these or not. These are summaries, so when you quote these, it's not the judgment, but it sort of is part of the judgment because it's released with the judgment, although as it says, this is issued to help people understand the judgment. But even then, you tend to reference bits in it. But anyway, I have my issues with this. But this says, it summarizes the claims here and says, if you're not familiar with it, Nurse Peggy alleged breaches of the Equality Act in relation to direct discrimination, indirect discrimination, harassment, including sexual harassment and harassment by rejection of harassment, and victimization. The claims were made both against her employer, Fife Health Board, and the first respondent, Dr. Upton, who is a trans woman and the second respondent. The claims related to the use by Dr. Upton of a female changing room, if you're not familiar, at Victoria Hospital, where they both worked after the board granted permission to do so. The case focused on whether the permission was lawful under the Act, what happened during a meeting between Mrs. Peggy and Dr. Upton in the changing room around midnight on Christmas Eve 2023, and then how the board had dealt with a complaint made by Dr. Upton about what Mrs. Peggy said at that meeting. The decision. In short, the tribunal found that the board had harassed Mrs. Peggy by failing to revoke the grant of permission to Dr. Upton on an interim basis after Mrs. Peggy had complained for the period until different work rotas took effect so that they would not work together, as a result of which Dr. Upton was in the changing room when the claimant was present on 2 occasions. Secondly, by taking an unreasonable length of time to investigate the allegations against her. Thirdly, making reference to patient care allegations against her on the 28th of March 2024 and giving an instruction to her not to discuss the case until a further message a little over 2 weeks later, which confirmed that it applied only to the investigation. And otherwise, the tribunal dismissed all the other allegations against the board and dismissed the claim against Dr. Upton. So bits of this, I think, will be appealed. I'll come back to those a little bit later. But the bit in green, which is also reference to part of what the judgment says, I'll come to in a minute, I find absolutely astonishingly bizarre. It says as follows: try to work this out in as much logic as you can fathom. Too much zoom. Right, let's try. It concluded that the decision did not result in it being inherently unlawful for a trans female who is biologically male under the Act to be given permission to use female changing room at work, but also that having the protected characteristic of gender reassignment did not mean that permission to use the changing room was necessarily lawful. Let's read that again. It concluded that the decision did not result in it being inherently unlawful for a trans female, biologically male under the Act, to be given permission to use the female changing room at work. So, not unlawful to give permission to essentially a man to use the female changing rooms. Now, I disagree with that. That's my personal view. I disagree with that. But it goes on. But also that having the protected characteristic of gender reassignment did not mean that permission to use the changing room was necessarily lawful. So it doesn't mean that it's lawful either. So it's not inherently unlawful and it's not necessarily lawful, which I think is a bit of an absurdity. It's a little bit like not really making up your mind. Now, the bit that I say is quite absurd is this bit here. There's, as you can see, it's a long judgment. This is paragraph 1049. This bit here I find quite absurd. It says, in our view, having read all of the documents, there is very far from sufficient reliable evidence to establish as a fact that a trans woman who is legally and biologically male is a greater risk to any person assigned female at birth, a woman, within a changing room environment at a workplace than another woman assigned female at birth. So, in essence, the tribunal here is saying there is no reliable evidence that a man is at greater risk to a woman than a woman in the woman's changing rooms. Now, I think that's patently absurd. I personally think that on an objective basis, what would an ordinary, reasonable, sound-minded person think about this situation? So phrasing this very slightly differently and giving you what this paragraph says and what I think as follows. Is it at all likely that a man poses a greater risk to a woman than another woman in the women's changing rooms? Now, this paragraph would tell you that it is very far from sufficiently reliable evidence that a man poses a greater risk to this woman than another woman in the women's changing rooms. I think that's absurd. I think the facts speak for themselves. It is, of course, as a matter of objective assessment, there is, of course, more risk to a woman by a man than another woman in the women's changing rooms. Now, this, of course, is not to say that every man poses a risk to a woman or that every trans woman, a biological man, poses a risk to a woman. But given the assessment, is it more likely that there is a risk to a woman by another man than a woman in the women's changing rooms? Of course, that has to be yes, surely. And unless I'm making a leap of logic there, which I don't think I am, I think there is an inherent risk to women from men that there is not from other women. Let me know in the comments what you think about that. This is an open discussion here. I mean no insult to anybody, and I don't mean to be disrespectful in any way, but I think that stands to reason. I think the facts speak for themselves. Res ipsum loquitur, as they say. The facts speak for themselves. Let me know what you think in the comment section to that one. I think it is very bizarre. It's a very strange paragraph, but inherently that's what it says here. In our view, having read all of the documents, there is I will look at what those documents are and what I really think about those. But it says there is very far from sufficient reliable evidence to establish as a fact that a trans woman who is legally and biologically male is a greater risk to any person, a woman, in the changing room than another woman. I think that's absurd. My personal opinion, even looking at it as an objective basis, that's what we can do. It's a bit odd. My subjective view is the same, and my view of what the objective view is going to be the same. Let me know what you think in the comments below. And as always, thank you for watching.